In this seminar, I'm going to be discussing the new as-is contract, the FAR/BAR contract. It became effective or must be used by October the 3rd, 2015 for only financing. In this seminar, it's going to be a brief overview, and if you'd like me to come out to your office, please simply call us at 954-563-7261 to schedule a time, and I'll bring the program to your office and we'll discuss the contract. If you would, at the very beginning, you'll note that there's a disclosure that I'm not a lawyer. I'm not an attorney, so therefore anything that you hear in this seminar that I'll be discussing with you is not meant to be legal advice, nor should it be considered or misconstrued as legal advice. Should you have a question regarding a contract law, we suggest that you contact an attorney who's reputable and knowledgeable in such types of documents, okay? So let's begin with kind of an overview of what makes a contract a contract. You'll notice in the first slide, a valid and enforceable contract. What do you have to have a valid, enforceable contract? As you'll notice in the first note, we talk about competent parties. You might remember that from your licensing courses. Competent parties took into consideration two things. Number one, the people that signed the contract had to be of legal age, and if they were not of legal age, that makes that contract possibly voidable. So, of legal age, and secondly, they had to be mentally competent at the time of signing. So if it could be proven that they had been doing drugs or whatever the case may be, that contract may not be an enforceable contract. So to begin with, competent parties. The very next note that you've got is offer and an acceptance. The buyer is going to make an offer to the seller. The buyer, therefore, if you might remember, is called the offeror. They submit an offer to the seller, the offeree who receives that offer, and at that point they'll either accept it, they'll reject it, or they'll make a counteroffer. Now it's very, very important that in the classes we talk about this, the buyer makes the initial offer, and I hear this all the time in offices. A new agent will come in and say, I just got a contract signed, stop. If the buyer made an offer an offer to purchase property, you don't have a contract yet because remember it takes two parties. The buyer makes the offer, it's called an offer to contract. If the seller accepts that offer, then that acceptance, real important note, must be reconveyed back to the buyer, and at that point it becomes an effective contract. That's the date that the contract actually becomes effective. So offer, acceptance, and then the last note is that acceptance must be recommunicated back to the person that made the offer. They must know that the seller accepted the offer. In the very next note, what they're doing must be for legal purpose. For example, if it could be proven that a buyer contacted a seller prior to a listing expiring, and that buyer said to the seller, look, don't sell it to me now, I'll come back and buy it after the listing expires, and we'll both save a commission. The bottom line, if that could be proven by the broker, they had entered into what's called a legally binding contract. It's not a legal contract because there was a conspiracy to defraud the broker out of a commission. That broker could possibly take it to court and win. Again, bear in mind, I'm not a lawyer, but that's what we teach in the real estate licensing classes. So competent parties, offer, acceptance, and recommunication of the acceptance back to the person who made the offer. What they are doing must be for legal purpose. And the next note, in writing. Now, you need to know this, that a contract doesn't have to be in writing to become a contract. In order for a real estate contract, though, to be enforceable, you might remember the term statute of frauds. The statute of frauds says if you want to enforce the contract, a real estate contract, it's got to be in writing to be enforceable. And then the very last note, you have to have consideration, okay? Consideration. You know, I ask my classes this question all the time. Do you have to have a earnest money deposit on that contract to make that contract a valid document? And the answer to that is no. Should you have an earnest money deposit? Oh, absolutely, because that shows the seller that the buyer is earnestly intending to buy the property or wanting to buy the property. So the purchase offer is the consideration. So on the top line there, when you're putting down the buyer and what their offer is, let's say $200,000, when you put on that line where it says purchase price or sale price or contract price, on that line where you had entered the $200,000, that would be the valuable consideration. Additionally to that, obviously the earnest money deposit would be very desirable because it shows the seller again that the buyer really wants to buy the property. So those are your essential ingredients that make a contract valid. C-O-L-I-C. COLIC is the acronym or the acrostic that we use sometimes in the classes. You have to have each one of those: competent parties, offer acceptance, and recommunication. Legality in writing. What they're doing has to be for legal purpose, in writing to be enforceable, and consideration. That makes a contract a valid document. In the next note, how do you terminate the contract? You'll notice, if you would, on this side here we've got offers, on this side we've got contracts. How do you terminate an offer to contract? And the answer would be a counteroffer would terminate an offer to contract. Acceptance of the buyer's offer would terminate the offer to contract. You have rejection. If the seller rejects the buyer's offer, you have termination of the offer. If there's a withdrawal by the offeror, that terminates the offer. And what you need to remember is this: when that buyer makes an offer, that buyer can back out of that offer to contract at any time prior to the seller accepting the offer and communicating that acceptance back to the buyer. So very, very important that you remember that if the seller really needs to sell, the property's been on the market for any length of time, and the buyer is making an offer but they've seen other properties, you want to let the seller know that, you know, until you accept and we recommunicate that acceptance, that buyer can back out of that offer without any penalty whatsoever. And if there was an earnest money deposit, it's got to be resubmitted back to the buyer. Okay? So you have withdrawal of the offer. You also have lapse of time. So if you had a buyer and the buyer makes an offer, and in the offer it says the seller has till 4 o'clock this afternoon to accept or reject or do whatever, the bottom line is when that time runs out, that offer is automatically terminated. Okay? Next note, you've got death or insanity. And I want you to remember this right here, because we ask the question in the classes, does death terminate a contract? And the answer is, well, you'll see here in just a second, okay? Death terminates the offer to contract, or let's say someone became insane or went insane. At that point, the offer would be terminated, okay? So on this side here, you've got counteroffer, acceptance, rejection, withdrawal by the buyer, the offeror, lapse of time, or death or insanity, and also destruction of the property. So if the buyer wants to buy a house and obviously it was hit by a tornado and leveled to the ground, the offer is terminated. Now, on the other side, let's take a look at once the offer becomes a contract, offer, acceptance, and recommunication, that's the effective date of the contract. What terminates a contract? You'll notice, if you would, performance will terminate the contract. Let's use a listing example as an example. When a seller signs a listing agreement with you, okay, if you find a buyer that's ready, willing, and able to buy, and you submit that offer to the seller, let's say the offer was for the seller's full asking price. If the seller doesn't want to accept it, or they say to you, look, I've decided not to sell, that's their choice. But you have performed, therefore you have the right to go after your commission, okay? So we've got performance. Next, mutual rescission. Buyer and seller can decide to terminate that contract. Buyer made an offer, seller accepted, acceptance recommunicated back, we've got a contract. They both decide to withdraw or rescind that contract. One thing you want to remember is that does not mean that the seller now doesn't owe you. You performed, you did what they asked you to do. If they want to back out, that's up to them, but you can collect a commission. Next note, impossibility of performance. Now, you'll notice there it says death is a possibility. In the FAR/BAR contract, in the as-is FAR/BAR contract, you'll notice in the very back, on the very last page, right above the signature line, it says, this contract is meant to be legally binding. If you don't understand it, don't sign it until you talk to an attorney. Make sure you talk to the lawyer before you sign it, because once you sign it, you're now committed. If you were to go back, I believe it's on line 548 or 458, under the topic parties. If you read that, it says the parties to this contract are the seller, the buyer, and the obligations of this contract shall inure or pass on down to the heirs and or successors. So the contract says contract can be terminated by death unless the contract states differently. So if someone were to die, that does not mean that the contract dies also. You need to read that contract, and that's why it's so important for buyers and sellers and you as a real estate professional to talk to them and go through this thing line by line, bearing in mind that you're not an attorney, you're not giving legal advice here, and you're going to ask them if they don't understand what they just read, they really need to talk to an attorney because the contract is meant to be legally binding. So we have death is a possibility. You also have a lapse of time. If the closing was set or financing was set to be accomplished or completed by a certain date and it didn't, that could terminate the contract. If closing didn't take place on a certain day, that could terminate the contract also. A lot of things can terminate the contract, okay? In your next note, bankruptcy. And in the last note, breach. You remember, if the seller decides to sell to the buyer wants to buy the property from the seller, and the seller decides to, I've changed my mind, I'm not going to sell my house. The buyer can possibly sue the seller for not only liquidated damages, but also, you might remember, specific performance, where the buyer says, look, I'm going to sue you for liquidated damage, or I'm going to sue you for money, return of my deposit, but I also want you to specifically perform as you said you would in the contract. I want the property. And as you learned in your licensing class in the state of Florida, that the property can actually be given to the buyer in a specific performance suit. Okay? All right, with that said, implementation of this new law. Okay, and it's all about knowing before you owe. With all of the mortgage fraud and everything that we've had over the last few years involving lenders and appraisers and real estate agents and sellers and buyers and Wall Street, you hear that on the news a lot. The bottom line is they've come out with this new contract, and the concept is before we go to closing and that buyer sits down and signs a contract that could be for 30 years, okay? That could cost them everything they own if they don't comply with it. The bottom line is this: they need to know what their actual costs are going to be at the outset, at the closing table, and then also over the lifetime. They need to know what that is specifically before they owe. In other words, before they sign that document that then commits them for 15, 20, 30 years, they need to know exactly what the numbers are, and that's what this contract is all about. Okay, and you'll notice, if you would, in the new documentation, we're going to talk about 4 documents: the good faith and the initial truth in lending documents, and then also the HUD-1 and the final truth in lending documents. These 4 documents, good faith, initial truth in lending, HUD-1, and the final truth in lending, these 4 documents are now converted down into 2 documents. And you'll notice on document number 1, the loan estimate. The loan estimate combines and replaces the good faith estimate and the initial truth in lending statement. The form highlights the most important elements of the transaction and allows for easy comparisons so that your buyer, this person that's going to apply for a loan, can compare the cost, one lender to another, okay? So that's document number 1. That's the new document. And it came from good faith and the initial truth in lending. Document number 2, the closing document, closing disclosure. The closing disclosure combines and replaces the HUD-1 settlement statement and the final truth in lending statement. The form mirrors the information provided on the loan estimate. So when they got the estimate, okay, the final closing disclosure should mirror what this said here. Okay, these are the final numbers, these were estimates, as the term implies. So today, if a person is going to get a loan, if they're going to get financing for their property, they're going to be, they will have a loan estimate given to them, okay, 3 days after the application is taken, must be submitted to them 3 days after the application, and then they will be given the final closing disclosure document 3 days before the actual closing. So 3 days after application, initial application, and then 3 days prior to the actual closing statements. That's when those documents must be presented to that buyer. Okay, and I know that this is very, very difficult to see, but this is what the buyer sees, the borrower sees when they go to the federal website. Loan estimate with all of the information here, like discount rates and points and things like that we discussed in the licensing course. But everything is right here, and then on the other side they can simply point, click, and check whatever they want to know about, and it explains what they're actually looking at and what they're actually going to be putting on the documentation. Okay, this is the second. Remember, 2 documents: loan estimate, that's what this is. point click, point click, point click, explains what the buyer is going to be signing, okay? And then the closing cost details, the disclosure, that's the second document, point click, point click, point click, etc. That explains that also to them. And then additional information on the loan. So there's only 3 pages here. Page 1, loan estimate, page 2, closing cost details, and then additional information on the loan. And that's basically it. So with that said, let's go on into the new as-is purchase agreement, the FAR/BAR contract, and let's take a look at it. And we're not going to be reading this line by line, but I'm going to be pointing out several things here to you that are important that you remember, okay? So if you would, you'll notice the parties, your seller and your buyer on the top 2 lines, obviously, and I'm not going to go into that, but real important to you is right here on line 14 and 15, D, personal property unless excluded in paragraph explains that. Here's one of the things that you might want to remember. In this, it talks about fixtures. In this contract, it talks about fixtures. And you'll remember that there's only really 2 types of property. There's either real property, which is the land and anything attached to it, or personal property. That's something like a video camera, like a pointer, like a suit, like a refrigerator, etc., etc. And then we talked about that third gray area. There's only 2. There's either real or personal. But then you talk about the third area, which is referred to as a fixture. And a fixture used to be personal, and because of the intention of the seller, they attached it to the property. Like, for example, that LCD projector in our ceiling here, it's attached to the inner working of that ceiling and the electrical lines, etc. That's going to stay unless somebody wants to remove it, okay? So the bottom line is, I wrote a contract, or one of my agents wrote a contract many, many years ago, and I'm busy typing a manual for a company that had asked me to do some training. My love is education and training. And my agent came to me, handed me a FAR/BAR contract, and I looked at it as I'm busy typing. I'm looking at it, looks good, looks good, looks good. And then down under personal property, where it said personal property, right here, okay, personal property, he had put in there one refrigerator, 1 washer, 1 dryer, stays with the property. Now, they were personal items. They were not built into the walls, okay? The bottom line is 1 refrigerator, 1 washer, and 1 dryer. And I looked at it, and just briefly, I said, it looks good to me, because all we're doing there is filling in the blanks. Remember, we can't draw up contracts. We fill in the blanks on a document that was prepared by the Florida Bar and the Florida Association of Realtors. Well, make a long story short, the second walkthrough, the day of closing, we went out to do a second walkthrough in the morning, and I hear this scream. I'm in the back with the husband, and we hear the scream from the kitchen, and it was the wife. We come running out, and what's wrong? What's wrong? And she says, that's what's wrong. And she pointed to the refrigerator, and I'm sitting here looking at this. Something looks different. What had happened was Mrs. Seller had taken a brand new Sears Kenmore stainless steel side-by-side freezer combination and put that brand new unit up on her U-Haul, and the U-Haul's locked up and she's ready to move out. Well, the bottom line was, in place of that brand new Sears, Kenmore, etc. commercial unit, if you wanted to call it that, it looked like one, Mrs. Seller had gone down to the local used appliance store and picked up a refrigerator that had been spray painted and put it in that corner. Well, I was the listing agent, the listing company, and also the selling company, and I knew a little bit about law because I'd been teaching it for a few years, and I knew that, what's the contract say? What does this say? My agent, my fault, my agent, my fault. My agent, my associate, had put down there 1 refrigerator, 1 washer, 1 dryer, with no description, no model number, no serial number. And I've had people say to me, well, couldn't they just take a picture? Yes, but. Couldn't they just take a snapshot? Yes, but. You want to take and put it on the line. 1 Sears stainless steel, model number, da-da-da-da-da-da, refrigerator, freezer combination. I wound up having to buy it because the seller, they got their money, they've moved out of town, they're gone, I'm the one that's there, and the buyer is going to be in that home for the next 5, 10 years, whatever, and it was a small town, Plant City, Florida, if you've ever heard of that city, and you bump into each other on the streets every weekend. So I didn't want that to happen, so I wound up buying a brand new refrigerator. The house was a $50,000 house. My commission was 6%. Total commission was $3,000. I bought one of those refrigerators for the buyer to maintain a good reputation. But my wife said to me, and I jokingly kid about this in the class, but it's true, she says, if you're going to buy them a new refrigerator, I want one too. So that commission went upside down out of my pocket, and oh well, it was a learning experience, hopefully. So the whole point here is, remember one thing. Anything that's not attached, permanently attached. Do you remember the word IRMA? I-R-M-A. Intention, relationship, method of annexation, adaptability of the article. If it's not, if that personal piece of property has not become a real property through attachment, okay, you need to make sure that you write it down, specifically state model number, serial number, the colors, whatever the case may be. Real important to you, otherwise you'll wind up buying something. Okay? Moving on, the next note. Down at the very, very bottom, under purchase price, down at the very bottom of all of these 12 pages, you'll notice that there's buyer's initials for Mr. and Mrs. Buyer, initial for him, her, and seller's initials for him and her. That simply shows that they have received a copy of page 1 of 12. Okay? Nowhere in the law does it say that initials, signatures at the bottom of each document makes that contract a valid contract. Valid contract, competent parties offering acceptance, legality in writing, and consideration. Down at the bottom, you have them initial each one of those documents to show that they have received a copy of that written document. Okay? Next, you'll notice time for acceptance of offer and counteroffer and effective date. On line 43, the effective date, really, really important. So when I ask a class, you know, when is the effective date of a contract? When does a contract actually become, when does this paperwork actually become an effective contract that can be enforceable in the courtroom? And the answer is the effective date. Well, what is the effective date? Remember we talked about offer and acceptance? The offer, that's when the buyer made the offer, probably gave you the deposit check of when is to be taken. You submit that offer, which could be a day or more later, to the seller. They think about it for a day or two or whatever. They finally decide, okay, we'll accept the offer. At that point, offer and acceptance, the offer was made 2 days ago, 3 days ago. The seller says, yes, I'll accept. You do not have a contract until that acceptance, do you remember, is recommunicated back to the buyer. Congratulations, Mr. and Mrs. Buyer, the seller accepted your offer, and you want to email that, fax that acceptance to, making sure they get a copy of the signed offer, okay, to the agent that's working for the buyer. That's the effective date, and that's when the clock starts ticking. If it says they have 5 days to do this or 10 days to do that, from the effective date, that's the date that's critical, okay? So if a buyer has 5 days to apply for a loan from the effective date, and the effective date was today, Friday, okay, Saturday and Sunday are not business days. Monday, Tuesday, Wednesday, Thursday, Friday by 5 p.m. That's how long they have to apply for that loan. And if you're representing the buyer, you need to be very conscious and be very aware of the fact that if they don't apply for the loan within 5 days by 5 p.m., then the bottom line is you may not have a contract, okay? So real important you remember the dates. And each one of these, they'll have the dates or the places to sign down at the bottom. Extension, the closing dates, occupancy. This has a lot to do with the new CFPB, the Consumer Financial Protection Bureau requirements. This is the new contract. And down at the bottom of the page, you'll see it says that this contract, copyright as of, I believe it says 9 or 10/15. I think it says 9/15 on this. Okay, this is the newest contract out. So the extension, the closing date, occupancy, possession, check if the property is subject to a lease, etc. Real important, real important. This is part of the new change in the new contract. Bearing in mind that the CFPB, the Consumers Financial Protection Bureau, their rules and their regulations is the consumer, they've got 3 days to get that loan estimate to them from the point of application, okay? And then from the point of actual loan closing, they've got 3 days before they go to closing that all of the documentation must be submitted to them. So if there was an extension or whatever the case may be, or something came up, or inspections, whatever, okay, under the closing, the extension of the closing date, they've exceeded it to 10 days. You'll notice it says there, it says, as a matter of fact, if paragraph 8B is checked and closing funds from the buyer's lender are not available on closing date due to Consumer Financial Protection Bureau closing disclosure delivery requirements, okay, then the date shall be extended for such a period necessary to satisfy those requirements, but they shall not extend to 10 days. So you need to be aware of the extension of closing and what might cause that, where the closing is not going to take place as stated in the contract, but it may need to be extended, and what rules and regulations. And you need to go over that specifically with your broker, or if you're using a lender, ask them to explain it to, or give us a call, okay, and we'll bring the course again to your office where we can discuss it in depth, okay? Under financing, this is critical. Again, remember, the new rules and regulations, the new documentation, only apply to somebody who is getting financing, okay? Getting financing. And then down here at the very, very bottom, you'll notice that there are places for the buyer's initials, that they've received all of this information, that they understand it, and then the seller's initials also. Moving on to closing costs, one of the things that we've always taught, even though this is in writing here, even though it's in writing, the bottom line is all closing costs are negotiable, okay? Somebody says who normally pays for the dock stamps on the deed, 70 cents per 100 there, or any fractional part thereof. You'd remember that from your course. Well, anybody can pay the closing costs, whatever's negotiated, okay? So just because it says something in the contract, the seller says, look, I'm not going to pay for that. The buyer says, okay, I'll pay for it. Seller says, I'm not going to pay for it. Buyer says, I'll pay for it. The broker even has paid for things like that, particularly if they don't refer to the actual financing, because if you paid for something for a buyer, then the lender would obviously have to know about that. Where did that money come from, okay? But that's something a little bit more in depth than what I want to get into here. So closing costs to be paid by the seller, closing costs to be paid by the buyer. In your next page, we talk about costs to be paid by the buyer down at the bottom. Don't forget, you've got places for the initials. Next, you've got surveys and home warranties. Very, very important part of the contract is if your real estate company has a home warranty program, you need to be showing to everyone. If you show it to only one person and you don't show it to another person, they can come back on you for discrimination, okay? The buyer, wouldn't you hate a buyer to say to you, you know what, I wish you'd have told me about the home warranty, because I just bought the house, I took every dime I've got to buy that house out of savings, etc., and the air conditioner blew up. The minute I moved in, the next day the air conditioner blew up. Now I've got to pay for it out of my pocket. Wouldn't it be a shame if your company had a home warranty that would have covered that, you just didn't explain it to the buyer? Or let's say that the air conditioning pump blew up while the property was on the market. You had listed the property, you didn't share the information that a seller can have their property covered while you're trying to sell it, and if anything goes wrong, all they do is they pay a small deductible, and the home warranty company comes out and either will repair it or replace it. You need to read the contract on that. But home warranties, any home that I've ever purchased, in all the years I've been in real estate, I've always insisted on the seller giving me an additional home warranty. Sellers are competing against that with new home builders. New home builders give home warranties. Anytime I buy a computer, I get an extra warranty that covers that. I want to be able to take the computer in, hand it to the company, and say, here, it ain't working, have them fix it or replace it, or give me a new computer. And that's what those home warranties actually act, in essence, as. They're kind of a risk control factor for you also, because the likelihood of a seller buyer coming back and suing me or you in the event that the AC compressor blew up, which happened to me in Brandon, Florida, the bottom line would be is if all they had to do was pay $25 to call an 800 number and the repair person comes out and either fixes it or gives them a brand new unit based on what the contract says, the likelihood of them coming after me because I didn't disclose or whatever the case may be, they blame the realtor, then the bottom line is it's risk management is what it is, okay? If you are dropping on down to the very up here at the top, rather, under permit disclosures, what do we find in real estate today? We find a lot of companies out there. A lot of people buy a piece of property, and the seller, during the middle of the night on Saturday night, got him and his family over, and what they did is they added a third enclosure on the back of their house, all without applying for, what is it? Applying for permits. Yes, the permit was never closed. So therefore, as a real estate agent, it's very, very important that you make sure that the seller understands that anything that they're going to sell to a buyer has been closed before it goes on the market. And then down at the bottom, of course, you've got room there for the buyer and the seller's initials. On the next page, we talk